Hi, we're Group 7 and we're doing Chapter 3, Equal Employment Opportunity. My name is Ashley Bakalarski.
I'm Cameron Pasinski.
I'm Darren Sandstorm.
And I'm Cameron Schweitzer.
So first, we're going to go over some of the key terms from this chapter. We have Equal Employment Opportunity, which is short EEO, and that is a set of laws/policies that require all people equal rights in the workplace, no matter the race, color, sex, religion, national origin, age, or disability. The next term is affirmative action, and that is requirements that companies need to make a positive effort to hire and promote employees from diverse groups in the labor force. And then the last term is diversity, which is any perceived difference among people, including race, age, religion, profession, sexual orientation, lifestyle, and many others. First, we're going to look at Title VII of the Civil Rights Act of 1964 that made it illegal for an employer to discriminate in hiring, firing, promoting, or compensating based on race, color, sex, religion, or national origin. It also forbids retaliation against any employee who participated in an investigation, proceeding, or hearing that may be against the company. And it now includes discrimination based on sexual orientation and gender identity, which is also now made illegal. The Equal Pay Act of 1963 was passed as an amendment to the Fair Labor Standards Act. It prohibits employees from paying a woman less money than a man when they are doing work that is substantially the same. It covers work within the same physical business. So, for example, different states could pay different amounts based on the cost of living. And exceptions include seniority system, merit system, and any other factor that does not include sex. And next, I'm going to be talking about the Pregnancy Discrimination Act of 1978. It prohibits discrimination in employment based on pregnancy, childbirth, or other related medical conditions. A pregnant woman must be treated the same as other applicants/employees. A pregnant woman cannot be fired or refused a job promotion because of that. And they must be allowed the same disability benefits, sick leave, and health insurance on the same basis as other employees for medical reasons. The Civil Rights Act of 1991 amended 5 statutes to provide appropriate remedies for intentional discrimination and unlawful harassment, to codify the concepts of business necessity and job relatedness, to confirm statutory authority, and to provide guidelines for taking legal action. Expanded the scope of relevant civil rights statutes to provide adequate protection to the victims of discrimination.
Right, next is the Rehabilitation Act of 1973. The Rehabilitation Act of 1973 prohibited discrimination against disabled workers who are employed by government contractors and subcontractors and the organizations who receive federal grants totaling more than $2,500. Protected under this act are diseases/conditions such as epilepsy, cancer, cardiovascular disorder, AIDS, blindness, deafness, mental illness, emotional disorders, and dyslexia. Next, the Vietnam Era Veterans Readjustment Assistance Act of 1974 requires government contractors and subcontractors to take affirmative action to employ and advance veterans protected by the act and prohibit discrimination against such veterans. It requires federal contractors and subcontractors to report the number of employees who are veterans covered under this act. Next is the Americans with Disabilities Act of 1990. It prohibits discrimination against qualified individuals with disabilities. It prohibits discrimination in all employment practices, hiring, firing, advancement, compensation, and training. Next is the Uniform Service Employment and Reemployment Act of 1994. This provides protection for Reserve and National Guard members, allows workers to return to their civilian employment after completing their military service. Workers will not be penalized for time spent on active duty exceeding up to 5 years. Equal Employment Opportunity Commission. After Title VII of the Civil Rights Act was amended, it created the EEOC in charge of upholding most of the acts that listed before. Discrimination can be taken to a presidentially appointed EEOC commissioner. Charges may be made by any aggrieved person or any acting on behalf of the aggrieved person. Office of Federal Contract Compliance Programs, the OFCCP. The OFCCP is an agency within the U.S. Department of Labor. It enforces the requirements of affirmative action and the EEO required for employers who do business with the federal government.
Different types of unlawful discrimination. There's the desperate treatment. Any employer who treats someone or some employees less favorable than others because of race, religion, color, sex, national origin, or age. Then the adverse impact. When an employment decision, practice, or policy has a disproportionately negative effect on the protected group. And then there's an example down at the bottom. Who is responsible for ensuring the equal opportunity? The Equal Employment Opportunity Commission, or the EEOC, administers most of the previous laws we have discussed. If you file a discrimination charge, it initiates an EEOC action. In 2016, over $52.2 million in monetary relief was provided to those who faced discrimination with the help of the EEOC. The Office of Federal Contract Compliance Programs, or the OFCCP, make sure that those who do business with the federal government are following proper affirmative action guidelines. They also help contractors understand regulatory requirements and will conduct compliance evaluations for them. And then it is the employers, it is up to the upper levels of management to create strong anti-discrimination policies that clearly state what it is or isn't acceptable behavior. Guidelines on sexual harassment. Employers are liable for acts of supervisors, whether they are aware of the harassment or not. The Civil Rights Act of 1964, it means that you cannot discriminate against employees who participated in an investigation, proceeding, or hearing. And firms responsible to develop programs and policies to prevent workplace sexual harassment. Guidelines on discrimination because of national origin. Other than direct discrimination, Title VII also covers marriage, association with someone of a specific heritage, marriage of a group that promotes national interest, participation in place of worship by people of a national origin group, and the use of individuals' names or spouse's name that is associated with a national origin group. And then guidelines to discrimination because of religion. Employees have been obligated to accommodate to religious practices if requested. It is not higher than a minimum cost to the employer. Employers that refuse need to provide evidence that accommodating would constitute an undue burden, meaning significant difficulty or expense. Unions need to also accommodate religious beliefs as well.
All right, and now we're going to go over guidelines on caregiver discrimination. So caregiver discrimination is discrimination against any employees based on obligations to care for their family members. In recent years, there have been an increasing number of claims. Some examples of this are treating male caregivers more favorably than female caregivers, giving new mothers unwanted jobs, and lowering work performance for female caregivers. And then discrimination because of disability. EEOC states that it's illegal to do medical examination to find out about an applicant's disabilities, and you're only allowed to ask about ability to do your job. You cannot ask about previous medical conditions or previous drug use. Diversity management. So the term diversity management, it's ensuring factors that are in place to provide for and encourage a diverse workplace. It's about pursuing an open-minded and corporate culture, combining actual and perceived differences achieves maximum productivity. And then having a diverse workplace should be the goal for a company because you have more minds, working together. Elements of the diverse workforce, key terms. So glass ceiling, it's an invisible barrier in organizations that impedes women and minorities from career advancement. Returnships lets organizations try out professionals who are resuming their careers, and then dual career families. Both spouses or partners have jobs and family responsibilities. So for our case study, it was so what's affirmative action? And we were introduced to the Supreme Construction Company. It was a small company originally founded by Alex Boyd in Baytown, Texas. Up until the early 2000s, the company never employed more than 15 people and mainly focused on small scale projects such as freestanding shops or offices. So not a very big organization. And in 2012, Boyd's son, Michael, who also worked for the company, suggested that they should start tackling bigger projects because they started growing in scale. Supreme's workforce had grown to 75 employees, and the company started working on a larger scale, now building shopping centers and multi-story buildings. And then in 2013, NASA released specifications for 2 hangars that they needed built just south of Houston, Texas. Supreme got the low bid for the project for just under $2 million, but the acceptance letter was contingent on submitting a satisfactory affirmative action plan. So for our discussion questions, the first 2 we answered ourselves, and the first one, explain why Supreme must submit an affirmative action program, and that is because since 1965, government contractors have been required to submit their affirmative action plans, and due to the fact that the NASA job is a government contract, Supreme must comply with this executive order. And then generally, what should that program be designed to accomplish? Affirmative action seeks to help a company foster employment opportunities by being more inclusive and avoiding discrimination. This includes hiring people of different races, genders, national origins, ages, and a variety of other protected statuses. And then our next 2 questions are for the class. The third one came from the book. It was, in conducting a utilization analysis, Michael discovers that although 30% of general population of construction workers are Black, only 10% of Supreme's employees are Black. So according to affirmative action, what is Supreme required to do? And the next question we pose to you is, why should companies aim for diversity as a goal in their workforce?
And then here is our video.
Equal employment opportunity is equal opportunity in employment. Examples of legislation to foster it or to protect it from eroding include the U.S. Equal Employment Opportunity Commission, which was established by Title VII of the Civil Rights Act of 1964 to assist in the protection of United States employees from discrimination. The law was the first federal law designed to protect most U.S. employees from employment discrimination based upon that employees' or applicants' race, color, religion, sex, or national origin. Public Law 88,352, July 2, 1964. Employment discrimination entails areas such as firing, hiring, promotions, transfer or wage practices, and it is also illegal to discriminate in advertising, referral of job applicants, or classification. The title is pertinent in companies affecting commerce that have 15 or more employees. The Equal Employment Opportunity Commission (EOC) is Section 705 of the title. Equal employment opportunity was further enhanced when President Lyndon B. Johnson signed Executive Order 11,246 on September 24, 1965, created to prohibit federal contractors from discriminating against employees on the basis of race, sex, creed, religion, color, or national origin. Along with those 5 protected classes, more recent statutes have listed other traits as protected classes, including the following. 1. The Age Discrimination in Employment Act of 1967 has protected those aged 40 and over but does not protect those under the age of 40. 2. The Americans with Disabilities Act of 1990 protects individuals who possess, or are thought to possess, a wide range of disabilities, ranging from paraplegia to Down syndrome to autism. However, it does not force an employer to employ a worker whose disability would create an undue hardship onto his business. For example, a paraplegic cannot work on a construction site, and a blind person cannot be a chauffeur. Similar protections have been in place for federal employees and customers of federal agencies and contractors since 1973 under the Rehabilitation Act. 3. The Genetic Information Non-Discrimination Act of 2008 forbids discrimination on the basis of family history and genetic information. 4. The Vietnam-era Veterans Readjustment Assistance Act of 1974 forbids discrimination on the grounds of a worker's military history, including any effects that the battlefield might have had on the worker's psyche. 12 states, over 100 local governments, and the District of Columbia have passed statutes that forbid discrimination on the basis of sexual orientation. Also, the Employment Non-Discrimination Act would allegedly make sexuality a protected class, but this bill has yet to pass Congress. The executive order also required contractors to implement affirmative action plans to increase the participation of minorities and women in the workplace. Pursuant to federal regulations, affirmative action plans must consist of an equal opportunity policy statement, an analysis of the current workforce, identification of problem areas, the establishment of goals and timetables for increasing employment opportunities, specific action-oriented programs to address problem areas, support for community action programs, and the establishment of an internal audit and reporting system.
And that was the rest of our presentation.